Good afternoon, Justice Unterhalter.
Good afternoon.
How are you this afternoon?
I'm very well. How are you, Chief Justice?
No, at least you are asking me how I am. I am fine, thank you.
Good.
Thank you very much for making yourself available for consideration for one of the positions on the Constitutional Court. I know that at least this is the third time you are making yourself available for a position in the Concord. Thank you very much for making yourself available. A number of us here in the Commission took part in your interview in October. We have before us the transcript of that interview, so we are quite familiar with a lot of information about you. And of course, we have got the questionnaire and your CV. Speaking for myself, I do not propose to ask you a lot of questions precisely because I did benefit from the interview that we gave you in October. It may well be that there will be other commissioners who will take the same position as me, but there are commissioners who were not there in October and who might wish to ask you quite some questions to get to know you better. But even those who were present in the October interview might wish to ask you a little more questions. So I will ask you some questions aimed at just refreshing our memories on some basic information about you, and after that I will allow commissioners who wish to put questions to you to do so. In terms of your qualifications, you possess, you hold 4 degrees. The first one being BA, which you got from Cambridge in 1980, is that right?
That's correct, Chief Justice.
And you got your LLB degree from the University of Wits in 1984, is that right?
Yes, that is correct.
And then you got your BCL from Oxford in 1985, is that right?
Yes.
And you got your MA from Cambridge in 1987.
Yes.
I do recall that from the October interview, that by the time you made yourself available for appointment to the bench, or by the time you got appointed to the bench, you had been in practice for something like 27 or 28 years, is that right?
Yes, I think it's 27 years. Chief Justice.
Yes. And in your practice, you appeared in many courts, including, of course, the High Court, the Competition Appeal Court, the Supreme Court of Appeal, and the Constitutional Court. Is that right?
Yes, that's correct.
And with special reference to the Constitutional Court, there is a long list of reported cases in which you appeared over the years. Is that correct?
Yes, I have had the privilege of appearing in that court for a very long time, almost since the inception of the court.
Yes. And you have written also numerous articles that have been published, and you have also, I think if I recall correctly, made some contributions, some books as well.
Yes, that's correct. I did pursue a set of academic positions at the same time I was at the bar, and so sought to publish as best I could, and some of those efforts are reflected in my CV.
Yes. I do not propose to go through a lot of the information because it is before us. your CV, in your questionnaire, in the transcript. We are aware of it. But I know that you are currently acting in the Constitutional Court, is that right?
Yes, that's correct.
And is that from mid-January this year?
Yes, I started in the middle of January, and I'm going to act. I've acted for the first term, and I've been asked to act for the second term this year as well.
Yes. How have you found that experience?
It's been a very, very enriching experience. Having appeared before that court for so many years, of course, to see it all from the other side is a very different matter. But it's been an enormously enriching experience. It's a very collegial court where I've been welcomed. The cases are enormously interesting and challenging. It's a hard-working court. There's been a great deal for me to learn about the court and the way it works. But it's been a very, very good experience for which I'm very grateful.
Yes. You have now been a judge for what, 4 years or 4.5 years?
Just, yes, for just over 4 years.
Sorry?
Just over 4 years. 4
Just
years
over
and
4 years, yeah.
4 months, I think.
Yes. Okay. Have you handed down any judgments that you have written in the Constitutional Court or not yet?
No, not yet. Those are
Yes.
still in the process of being
It will
dealt
happen
with.
soon.
It will happen soon, yes.
Yes, okay. I will now allow commissioners who may wish to ask you questions I will allow them to do so. And I just want to mention that in doing so, to a very large extent, they will be seeking to see how your appointment would satisfy the selection criteria that were approved by this body in 2010, which continue to apply. And without reading all of them, I just mentioned that some of them are whether you are a person of integrity and whether you are a person with the necessary energy and motivation, and whether you are a competent person, technically competent, or whether you have capacity to give expression to the values of the Constitution, and whether you are experienced in regard to values and needs of the community, and what message your appointment would give to the community at large if you were to be appointed. Of course, there is the question of whether you are appropriately qualified and whether you are a fit and proper person. Very largely, commissioners will ask you questions seeking to see how your appointment would satisfy these criteria.
Yes.
Thank you. Commissioner Nyambi.
Thank you, CJ. Afternoon, Judge.
Good afternoon.
I'm on your right.
I'm sorry I didn't see where you were.
I'm very close to where you are. The first question is about the previous interview, as CJ has indicated that you were interviewed twice last year.
Yes.
Probably you might have gone through the transcript, and anything that you might want to reflect about out of what was said in the previous interview coming here today that you think it's more than significant, that can assist you to stand out, that you might have not have ample time to deal with it then, or you have reflected about it and you have changed your views about it, about what you said to us in your previous time you were here twice last year?
No, there's nothing in particular, but I'd be very happy to take any questions that arise from it.
Okay, linked to that, as you came twice last year, sitting here today, what is it that is totally different to the judge that we interviewed last year twice, so that we must seriously consider as this commission this time around?
Yes. Well, obviously, I have had the privilege of acting for a term in the Constitutional Court. And since that's the court that I aspire to sit in on a permanent basis, I think that's been a very, very helpful experience, both in understanding how the court works and engaging in the important work that it does. So I would say that that is a relevant factor that is additive to the things that I've already placed before the Commission for the purposes of considering my position. You will also see that I have sent through to the Commission a number of the judgments that I have written in the Supreme Court of Appeal. And I think that's a not inconsiderable body of work, much of it reflected in the law reports, and I'd be happy to take questions on that, but I think it reflects both my interest and the way in which I go about deciding cases. So I'd say those are the two things you might want to reflect upon.
My last question is about Section 167, subsection 2 of the Constitution,
Yes.
the quorum of the Constitutional Court.
Yes.
If you can share with us your view about it.
Is there some specific question about the quorum?
The issue of having 8.
Yes. I think there are different views as to precisely what the quorum should be. My own view is that if the Constitutional Court, as it is intended to, hears cases of the greatest importance, which resolve issues of law that then become a durable part of our constitutional and legal framework, I do think that a quorum of 8 is, generally speaking, the appropriate quorum, because one does want the benefit of all the minds that can be brought to bear on the very important questions that the court considers. And so, although I know there are other proposals about structural change, and I'd be happy to address those if it's of interest, for the moment, in the structure of the court as it stands, I do believe that that quorum is the correct quorum.
What about a situation where you have got a split of 4-4?
Yes. Well, that can give rise to the somewhat unfortunate result that then the decision that prevailed in the Court of Appeal from which the appeal lay would then prevail by default. So it can be an unfortunate consequence. Generally speaking, it's obviously better that more of the judges should sit, but there are also exigencies around other duties that judges have and other commitments that don't always make it possible. So you may well be right. Perhaps an uneven number is the better number, and so perhaps 9 would be better, but one has to also be practical about, is it always possible to assemble that quorum? And we have seen in the past that it has not always been possible. So I completely take your point. It's much better that a decisive outcome is achieved rather than an equality that simply gives rise to a default rule. But one has to also yield to some practicalities.
Thank you, Judge Unterhalter. Thank you, CJ.
Thank you. Before I go to Commissioner JSC, Justice Unterhalter, when you were here in October, you had occasion to mention some of members of the bar that you had been able to assist or give support to. Is there anything arising from what you said then that you might wish to revisit?
Yes, indeed, and thank you for the opportunity, Chief Justice. A query was placed with me yesterday as to my reference reflected in the transcript at page, I think, 62, where I referenced Councillor Beloy. I've, since as my communication, which I hope has reached you, indicated.
It only reached me now.
Oh, I'm sorry.
Yeah.
I did send it first thing this morning, but I did indicate that I had checked that reference, and it was my error. I had made a mistake because in the matter of MTO forestry and the Competition Commission, I had thought that I had led Councillor Beloy, whereas in fact she acted for a respondent, and we were effectively on the same side, but I was not leading her. I have, if it would be of any assistance to the Commission, since drawn up a list of those junior counsel, some of them have since become senior counsel, and some judges, who I did work with, who were black practitioners and women, and I'd be very happy to make that available, because that is a list that has been checked. So if it's of use to the Commission, I could make that list available.
Yes, maybe they might be able to make copies for
Certainly.
everybody if that facility is available at the Secretariat. Yeah, okay, all right. They will probably take it after.
Certainly.
Okay, all right. Commissioner Jesse.
Thank you, CJ. Good afternoon.
Good afternoon.
Firstly, I note the Law Society of South Africa speak well about your judgment and publication, but my attention is particularly drawn to what Nadel is saying. I will read for you. I mean, paragraph 53 of their comment. Advocate Mugaitobi's nomination essentially entails three considerations. The first is that the candidate's acting stints have played a role in developing the country's jurisprudence. The second is that his judgments demonstrate his strong judicial skills. The third is that the candidate's judgment also demonstrate a commitment to the underlying values of the Constitution.
Yes.
That's a huge statement from these two organizations, to which I can find no fault, and obviously even on the last occasion. There's been a question I've asked from all the previous candidates. The question is, if you are sitting at the SCA as a judge, leave to appeal served before you, and shortly thereafter, you are appointed to the Constitutional Court. That leave to appeal comes to the Constitutional Court. Are you entitled to sit?
If it's an appeal from the SCA, the answer would, I think, be not, unless there's some distinctive feature of the case. But no, I think the answer would standardly be no.
Yeah, I'm asking you this question, Judge, because in the course of my preparation for this interview, I came across two orders. The one issued by yourself and Judge Chomi in the SCA on 8 August.
Yeah.
In the matter of Ken Joan Lindek, Eskom Holdings, SO, and Mogale City. In that matter, you dismiss the special leave to appeal. Shortly thereafter, this year, you sit in the SCA in the full court comprising of Justices Kolapen, Matlanga, Majid, Matopo, Hlanhla, and others. You sit in that bench for the same matter, and you dismiss the leave to appeal by those parties. That's a serious concern to me, I have.
Yes,
I'm worried that maybe you may not have the orders, I can give it to you. But I came across this as I'm preparing for this particular matter.
I must say that
Before you
so sorry.
respond, Justice Unterhalter, if you are able to respond, even though this was not given to you in
Yes.
advance, it's fine. But if you are not able, because you would have needed time,
yes.
then we might have to deal with it differently. I don't know, maybe let me first ask, are you able to deal with it?
I would have to look at the two cases and see, I'm afraid. And I'd happily come back and answer as best I can. I recall very distantly the one, but let me have a look and I'll happily respond.
Yeah,
Maybe let
Chief
me,
Justice.
let me say this.
Chief Justice,
Oh, is it Commissioner Malema?
yes. No,
Yes.
sorry to come like this. The same, this matter was brought to my attention, and I gave it to
Ms. Van Niekerk.
Mr. Elbo yesterday because it came late. And I
Yes.
had hoped that this matter would have been given to the judge and to your good selves.
Yes. No, I want to address that. Ms. Van Niekerk mentioned to me that there was, I think, this complaint, or, yeah, there was a complaint from somebody. And the question was, she sought guidance as to how it should be dealt with, because as I understood the position, it's a complaint that came late, or comment that came late with regard to the candidate. And I said to her, because it's a complaint that came late, in terms of the decisions we took yesterday, it would not fall under the exception. So it should not be asked to sent to the candidate. You will recall that the general rule we agreed upon is that if it comes late, it should not be accepted, except if it falls into an exception. And the reason why I said it doesn't fall into the exception is this, that generally speaking, I don't think that a judge would intentionally sit in a matter where a decision in which he took part or she took part would intentionally sit, because they would know that they should not sit. But what could happen is that maybe there is oversight and so on. And I said, well, also the complainant, because he is late or she is late, they can lodge a complaint with the Judicial Conduct Committee, and their complaint about Justice Unterhalter having allegedly sat in a matter in which he should not have sat can then be dealt with by that body.
Sorry, Chief Justice, this one is not a complaint. I'm not part of that complaint.
Oh, okay.
I'm asking a question, and I explained that it
Yeah.
arises as part of my preparation, and I do not know how, and I cannot even reconcile, because the court order is a public document.
Yeah.
I don't need a complaint to ask this question.
Okay, so
Because
but you are saying,
what I'm saying is, I have 2 court orders here. This is what I pick up in the context of preparing, as I do for each and every candidate, this one and other candidates, because these are documents, and I'm asking.
yeah,
as
no,
part-
I understand you.
But I don't know about the complaint. No one has given me
Yes,
the
no,
complaint.
that's
Yes.
fine. But Commissioner Malema said it is a complaint.
Oh, I don't
No, no,
Or
Chief
did I
Justice.
misunderstand you, Commissioner Malema?
No, but also your response is what gives me discomfort.
Yes.
And if this is how we're going to proceed, then we're going to have a big problem. We have asked a question. Commissioner Nonchesi has asked a question. The candidate has said, well, let me look into this matter and then I'll come back. But the Chief Justice has already given an answer that I don't think a judge can sit intentionally in the matter. You have already answered the question for him. And I don't understand what is this, because you gave it to him. He said he needs to familiarize himself with the facts, and then you go beyond that to answer for him.
Well,
But you don't think a judge can sit deliberately on a matter? Already the matter is being answered.
Well, Commissioner Melema, I thought I owed you a disclosure of what happened when I was approached, so that you all know. And I shared with you what my thinking was. That is what I was doing, nothing more than that. Justice Unterhalter, you would like to check the facts
Yes,
about this?
if I may, I would like to check. I know there have been a number of matters in which I was involved in the SCA where I've recused myself when those matters came up for applications for leave to appeal. I'll look at this instance and come back to you. If I've done so in error, of course, I will indicate my error and make appropriate apologies.
Yeah. In fact, Judge,
Yes.
in fact, Judge, like,
One
just
second.
let-
Yes,
let me
Commissioner Notches.
explain this, Judge. The question from me
Yes.
is by no means an intention to convey some other meaning or to catch you up. It's just a clarity on this matter,
No,
which I would accept, including the clarity such as to say, well, I did not see whatever it is.
I will.
So I don't want this to create controversy.
No.
If, for me, your answer is, look, because I have these court orders, if you say I will check, if, well, I see, then I recall, and then that's it, we pass on. And I can assure you, take my word, it is not about catching you up, because all what I want to establish at the end of the day is how do you, for instance, between the SCA and the Concord, when you act there, how do you manage
Yes.
such issues?
Well, as I've indicated to you, I'm completely alive to the question. There are a number of cases where the record will reflect that I have recused myself precisely because I was involved in decision-making at the SCA level. And I will obviously look at what you have got there, and if I have fallen into error and made a mistake, I will acknowledge it.
Yes.
Okay, if you can let us have your response after checking
Of course.
at some stage tomorrow, that would be highly appreciated.
Of course.
Okay, all right.
So what is happening to me? I don't ask now. It's end of my question.
Sorry.
Because I was asking questions, I was stopped. I'm trying to clarify
Sorry,
things,
sorry,
so it must
Commissioner
end here.
Notches. Sorry, Commissioner Notches. Well, Justice Unterhalter has said he needs to check, and then he will revert and let us know.
Because I have the order, so that I stop here, I don't ask questions, I leave, and then everybody asks. If it's read at the end or it's not read, it's fine, but I had some questions that I was to ask.
Yes, no. You remember you have been asking one question with other witnesses. I thought that was the only one.
It's
But you can ask, continue.
It's simply because,
Chief Justice, maybe before he goes to the next question, it's Lamula.
I'm sorry?
Yeah, I heard you saying if you could answer, if you could respond tomorrow. My challenge is that according to this, we're going to have deliberations. So how are we going to handle that?
Well, I don't think he's able to check before today. So I thought that we might have to postpone our deliberations.
Okay.
Yeah.
Chief Justice, as I understand this from the judge, and I understand, if we can leave to him, he can simply say, today I want to get other document. Or he can say, I'm in a position, because this is a court order, it shows who appeared in that court, who appeared, what is the matter.
Yes, okay. Justice Unterhalter, do you want to respond to that?
I don't want to hold up your proceedings at all. I simply need to get access to my computer, and when I do so, I'll check and see how this arises, and I will come back to you and as soon as I possibly can.
Yeah, okay. Commissioner JSC, is that fine?
I'm happy.
Thank
So
you.
I will stop my questions at this moment.
Okay,
because-
all right.
Because we cannot take it further.
Chief Justice,
Yes,
my difficulty with that is that the candidate would have finished his interview and then he says he'll come back to us at a very, whatever convenient time. Does that mean he will have to come back? Because depending on the type of answer he's going to give, that answer may necessitate a follow-up, wanting to follow up on this question. So
Yes.
how are we going to do with that? Because depending on how people answer questions,
yeah.
that question may necessitate a follow-up. So how are we going to deal with that?
I think we should then say, ask him to come back tomorrow to give the answer in this forum, so that if his answer generates further questions, he can answer them. Would that be fine with you,
CJ?
Justice Unterhalter?
Certainly, I'm entirely at your
CJ?
disposal.
Yes, who?
Is Dodovu, Commissioner Dodovu.
Oh,
I want to
Commissioner
speak
Dodo.
on the same matter.
Yes,
I personally feel uncomfortable that we need to put this matter in abeyance because of a single question. My express view is that a candidate was asked a question. He's not certain about what transpired in that particular case. I think it's enough in the context of how we're moving forward, because here we are going to set a precedence that we have to call a candidate to come and clarify a particular matter here, something that has not happened in the past. My view is that when we consider the issue or the matter at hand and the candidate itself, we'll do that in the context of the information that is available at our disposal, and therefore make a view, express a view on how we must move forward. I think, in my view, that this that we have is sufficient, and we need to move forward along those lines. Thanks.
thank you. To some extent, it depends whether Commissioner Nochesi, what he thinks about that, because he is the one who had the question, and there has not been a definite answer because the candidate must check. Do you want to say anything about that view, Mr. Nochesi?
Chair,
I want to,
Chair, it's such
Yes.
that, it's such that I do not know how to approach now. I knew exactly earlier on, because I think I was in agreement with the candidate on two things. One, that he cannot sit there deliberately when yourself you indicated.
Please raise
But-
your voice a bit.
I was in agreement with the candidate. In fact, he answered when he says, look, I could not, did I sit on these matters when I was in that court and come and sit on appeal. All what I think he wanted to check is this, so that he's able to say, oh, well, this happened, I made a mistake. I mean, this is what it is, because we know the principle that he cannot sit. If that is what happened, because it's just a question of court orders, but now your view is that you need more time on this. To me, there's nothing, it's not in trial about this
Yeah.
matter. I'm not putting him on trial. I just wanted to clarify this, not only for this candidate, but for all of us, my education, other commissioners, and everybody listening outside there.
Well, if you say it's not a big issue for you to warrant that he should come back tomorrow or furnish other information so that we finalize everything today in regard to the Concord, if you say that, I would have no problem going ahead.
No, to me, it's not a big issue.
Yes, okay. All right.
Chief
Is there anyone who feels that?
I'm
this-
here on virtual.
Oh, Commissioner Malema?
Well, that is my question as well. If non-jazz is retreating from it, I'm sponsoring it because I don't know how the question of Advocate Baloyi arose, whether it was raised 7 days before or it was brought to the attention yesterday and it was also processed and we're able to get an answer today. This matter was also raised and there was a space in between. It is special for me because it has got everything else to do with the ability to make judgment for the judge. And when the argument arises that no, you can't say that because he has answered the way he has answered, we are going to use this in deliberations. And I can't use the things that we have not raised or that he did not respond to on this platform. So whatever we're going to say in the deliberations based on this should be coming from him and not what we suspect he said or we assume he said this. So that's why we should get a definite answer. Because for me, there are two issues. Is Advocate Baloyi's issue, is this issue, and then it has got everything else now to do with the judgment of the candidate. That how do you go around making such mistakes? How do you come here and say you mentored Baloyi or you led Baloyi in a case and not being sure? And then you come and say, no, I made a mistake. Then on this matter, he comes and say, okay, I made a mistake. There are two matters where a candidate for a senior position has made an error of judgment. And I will be using that to argue in the deliberations. And someone can't just come here and say, no, leave it. You can't get an answer from him. Just use what you got. They're going to litigate and say, he never said what you are saying he said. Because I know for sure on this candidate, all the time there are NGOs that are readily available to attack us. And that's why we must be thorough and we must be clear and we must get definite answers. Unless they say they are not prepared to entertain it, then we can use that. But if he says I can entertain it, let me have an exposure to my laptop, it's going to help all of us that this is his answer.
Yes.
Thank you.
Thank you, Commissioner Malema. Commissioners, this is the view I take of this matter at this stage. I'm not saying it's final, but let me say to you, we are here tomorrow. We are here for the rest of the week. I don't think there is anything problematic if we were to defer our deliberations. The candidate goes and checks what he needs to check. He comes in here tomorrow, and at some stage when it's convenient to us, we let him come in. It might be 10 minutes. He gives an answer. If there are no further questions, that's it. If there are follow-up questions, he deals with them. Then we know that we are done. Because it's not, I don't think it's right if there are members of the commission who feel strongly that an answer on this question should be obtained. I think that's what I think we should do. Can everybody live with that?
Before we do that.
Oh, before, let me, Commissioner Singh?
Yeah, thank you, Chief Justice. I don't know whether Justice Unterhalter has his laptop with him, but if he does have, I think it will be very helpful to all of us. Perhaps if we adjourn for half an hour or so, and through you as the chair, the documents which Commissioner JSC has on hand be provided to him just to jog his memory, because we don't expect him to come with all the answers here. And then we adjourn for half an hour, and then we continue and finish our interview, and we can deal with deliberations perhaps tonight or tomorrow. So I don't know if that's a possible way out of this.
Maybe what we should do is let's exhaust other questions, and then at the end we can then decide whether we go that route or another route with regard to this particular issue. So in other words, what I'm suggesting is that let's park this issue, let's continue with the interview, and once we are done with all other questions and the only one left is this one, we can decide at that stage whether we go the route of asking him to come back tomorrow or whether we go with the suggestion made by Commissioner Singh. Commissioner Klaba?
Yes, CJ, thank you very much. I want to agree with your proposition that says, let's park this issue and then continue with the interviews. And then the issue that the advocate needs to be aware of is that we need his response to this particular question before our deliberations. So we either postpone our deliberations, we're going to have the deliberations immediately after the sitting. We either postpone them to tomorrow morning, in which case we allow him time to come back. The issue, how is he going to come back? I think we can even take it by, he can come online on the time that you determine. We make a follow-up on this and then conclude and then go into deliberations. Thanks.
Yeah. Okay, all right. Are we agreed? Let's continue with the interviews for now, with the interview, and then when we are done, then we'll talk about this issue, how we move forward with it.
Chief
Can I
Justice.
just raise an issue?
Okay. Commissioner Pillay?
Thank you, Chief Justice. I would like to agree with Commissioner Malema. There are actually two issues which are unresolved. I wouldn't want to label the one the Beloy issue, but certainly the number of black women that the candidate has led while he was at the bar, I think that's still an issue that's unresolved. So if we are pending issues to be discussed tomorrow, I think it's important to emphasize that there's two issues thus far that remain unresolved.
Well, as we speak, I don't know of any reason why any other issue can't be dealt with today. I know why this one that we are talking about might have to wait until later. What I'm saying, if we continue with the interviews and there is a question that somebody wishes to ask with regard to the issue you are raising, that can be asked.
Except, Chair, on the black women juniors, we're waiting for the candidate to produce a list.
Oh, okay.
And that's why further questions will have
Yeah.
to follow once we receive
Okay.
that list.
No, that's fine. Can we continue with the interview, Commissioner JSC?
To do just for myself to complete, I want to hand over this so that on my side, so that you can see what I'm talking about.
That's fine, thank you. Okay, let's continue with the interview for now. Commissioner Moimang, had I given you a chance or not?
Not Chief Justice.
Okay, may I give you the chance now?
Thank you, Chief Justice. Good afternoon,
Good afternoon.
Justice Unterhalter. My question relates to whether there is a case in suggesting that there is lawfare in South Africa following the role that the court plays in promoting the values of our constitution. Secondly, does the constitution stand in the way of radical socio-economic transformation in terms of transforming the capital relations in South Africa, ownership, management, and control of key economic sectors? Thank you.
Well, let me answer both your questions. Perhaps let me begin with the second question first. Our constitution marks out two parameters fundamentally, which is that there are a bundle of fundamental rights which define a number of liberties that people have, as well as obligations that rest upon government to progressively realize the socio-economic rights. On the other hand, there are a scheme of separation of powers under the Constitution which give, as one would expect, considerable latitude and indeed obligations to the executive and parliament to shape the policies that, in the view of the government of the day, are relevant for the country and they are elected to determine. And I don't think that our Constitution dictates the kinds of economic policies that are to be pursued by one government or another. They permit of a very great range of economic possibilities, and by and large, those who might be committed to significant changes to economic relationships in this country will find that there is ample scope within the Constitution for that, bounded only, as I've indicated, by the fact that this is a constitutional democracy, and in a constitutional democracy there are certain fundamental rights which exist and which are to be honoured, notwithstanding what the government of the day offers. So that would be, in general terms, my answer to the second question that you pose. As far as the question of lawfare is concerned, there's been a great deal of discussion as to whether the courts have become places in which political battles take place. And I don't think that the courts have ever been immune from the fact that political actors will often seek to translate their political positions into legal arguments. What matters most fundamentally is that courts don't find themselves drawn into the rights and wrongs of particular political positions. And so it seems to me that when people speak about the fact that courts are overstepping, that can arise in one of three circumstances. The one is that an unsuccessful litigant does not like the way a court has decided. That's an inevitable feature of all litigation. Somebody wins, somebody loses. There are some who criticize the structure of the Constitution as it exists and would have it other than it is. Well, we know that that's a matter for constitutional change. And then there's the third question, which is, have the courts in any way overstepped the boundaries of what courts are there to do in upholding the Constitution? It would be that third category that one would want to look at very closely. But in my judgment, there are many issues of great legal importance sometimes are the result of political battles that litigants would fight. The courts don't translate that into political partiality. They must and always should determine the matter on the basis of the law and the constitutional order as we have it reflected in the Constitution.
Thank you, Justice Unterhalter. Thank you, Chief Justice.
Thank you, Commissioner. Justice Betzer.
Thank you, Chief Justice. I've got two. Good afternoon,
Good afternoon, Justice
Unterhalter.
Betzer.
I've got two questions for you. One is more of an observation, and I'll leave it to you whether you might seek to dispute it. I see from the bundle of documents here that you were nominated by Advocate Maleka, Advocates Maleka, Ngugai Toby, and Cecilana.
That is correct.
And having read those letters of nomination and the motivation for the nomination, I just want to make this observation. Your wealth of experience and extensive knowledge of the law was demonstrated during your several acting stints at the SCA, during debates with counsel in court, and deliberations that the members of the panel would have after the hearing. Do you wish perhaps to comment on that?
Well, I've certainly had, as I've indicated earlier, the privilege of acting in the SCA and now in the Constitutional Court. And there's a great deal to learn about how appellate justice works. But it has been one of the enormously enriching features of that experience that one engages in these courts with very talented counsel who come to submit before the court, and getting the best out of their submissions is part of what hearings are all about. Although the questioning is often rigorous, it's intended to be in order to get the very best advantage of what counsel can contribute. And then there is the wealth of experience and knowledge that colleagues bring to bear in thinking about cases and offering their views about it. And it is out of that judicial chemistry, if I can put it that way, that we get our thinking refined and the best of our judgments ultimately come to be made. So I've tried to make my own contributions to that process, and of course also greatly benefited from how others engage in what is the fundamental work of the appellate courts.
Thank you. My second question has got its genesis in the question that Commissioner Nokesi wanted to pose to you. And you are at liberty to indicate if you feel that we must park that question until tomorrow, after you have had the opportunity to investigate the matters relating to what Commissioner Nokesi wanted to raise with you. I don't know whether you are aware from your acting stints at the SCA, which is a common occurrence there, where you would have two judges of the SCA considering a petition, deciding to grant leave to appeal, and one or two of those judges would make up, together with three other judges, the panel that hears that appeal in due course. Similarly, from my experience in the Constitutional Court, where justices of the Constitutional Court would consider applications for leave to appeal, would dismiss one straight away on the basis either that there are no prospects of success of the intended appeal, or that it does not engage the jurisdiction of the court. In the one, it happens, they would decide to issue directions, file the record, and they set time frames for filing of the record, filing of heads by the applicant, and filing of the respondent's heads, and an indication of when the matter would be heard. And all 11 justices who are party to that direction, or whatever the number that constituted the quorum, would then hear the application for leave to appeal in due course.
Yes. That is entirely as I understand the procedure to be. As I understand the difficulty that's being put is that I would not have been competent to be part of any quorum that would have determined the application for leave to appeal before the Constitutional Court, and that's the matter that I will look into. I don't think it makes a consequential difference to the outcome, because there would, I assume, have been more than a quorum available to take the decision. Whether my assent, if there was an assent, is counted out of the calculation or not. So, but I will obviously look at the position, and but your understanding of the procedures, as I have come to know of them, is accurate with respect.
Thank you, Justice Unterhalter. Thank you, Chief Justice.
Thank you. Commissioner Makwanisha.
Thank you very much, Chief Justice. I think I must be protected from my discipline,
From who?
from my own discipline, because I do raise hands
Oh.
to make interventions, because I just don't just talk.
Yeah.
I think I need to be protected from that discipline.
I apologize, Commissioner Makwanisha.
No, thank you very much, Chief Justice. Good afternoon, Justice
afternoon.
Unterhalter. When you were responding to the question from the Chief Justice, I think I'm going to collapse two questions into one. When you were responding to the question from the Chief Justice, you said that you are still writing the judgments. You have not yet delivered the judgments in the Concord where you are acting now. Now, would it be fair that you just come for a few months, you have not even delivered one judgment, and then we expect you to be appointed to that court? Can you really say that you know that court? I think it's linked to also the question on the fact that in terms of one of the criteria that the Chief Justice has articulated, is that we must also consider the message that we are sending to society in general. Now, what message will we be sending? That you just come for 4 years, you jump to the highest court in the land, and there are other judges generally who have been there for quite a long time. And it's linked to the issue that I've just raised also with the Constitutional Court. You are appointed in January, if I'm not wrong. You are appointed in January. You are still in the process of writing judgments for that court. Then you are appointed. Can you assist us so that we have a compelling argument to recommend your name?
Yes, well, let me be clear. The judgment that I've been asked to write, I have actually written, but it's under consideration from my colleagues, so I can't do more than await their views on it, which are in the process of being determined. Of course, it happens that this interview comes at the end of the first term, and as you all know, the Constitutional Court follows a particular process by which judgments are produced. But I think that you will find that the work that I've done over the term that I've just been engaged upon has been quite considerable, and the results of that will become apparent when the judgments are yielded. So although you can't know everything as to what I've done over this period, that is something that will become apparent. And I think I can give you the assurance that I have very fully participated in the work of the court and will fully participate and continue to do so in the term that is coming. So I don't think that the proposition is somehow that I've just started and there's nothing by way of a record that is relevant to my suitability for consideration. The other point is this, which is that generally speaking, if one is privileged enough to act in that court, there is a limited time over which that takes place. So I'm not certain entirely what is the expectation of the Commission. How many times must one act in the Constitutional Court before one can be considered as a candidate for that court? It does seem that not only is acting not a requirement, but if it happens, a period of 2 terms would probably suffice as a reasonable training ground for the purposes of permanent appointment, and that has been a norm established over the years. As to the question as to the period of time that I have been a judge, I've made these indications to the Commission before, but let me very briefly summarize where I am on all of that. In a lengthy professional career, where I took time out from the bar to engage in the work I did at CALS and at the Mandela Institute and so on. There is only so much one can do in a professional life. And I took that time because there were a number of things that I wanted to do and achieve in the course of my professional life. In addition to the time that I took to serve at Cowles and in the Mandela Institute, I also spent time, as I've indicated before, at the WTO, where I served on the appellate body and chaired that body for 2 years, with a cumulative experience of some 8 years of judicial service in that capacity. Now, we can talk about how useful and relevant that is, but that explains why I, as it were, came to the South African judiciary relatively late in my professional career. And the ultimate question, I think, for the Commission, and certainly the one that I would suggest to you, is that the question is that cumulative experience of practice and judicial performance in the WTO and the other things that I've done in my career of value to a position in the Constitutional Court? And I would like to suggest to you that it is.
Thank you, Chief Justice. Thank you, Judge Unterhalter.
Thank you, Commissioner. At this stage, I'm going to go to the commissioners who are attending virtually to see if there is somebody who wishes to put some question to the candidate.
Julius,
Commissioner Malema.
thank you, CJ. Judge, is it an acceptable thing that, maybe let me put it differently, that we have observed a huge temptation to capture the judiciary, especially from the executive and politicians who want to use their judiciary to fight their political battles. And all of us without fail, have gone all out to protect the judiciary against politicians who want to capture you. Will it be an acceptable thing that some NGOs here must capture judiciary to serve their own interests because they are not political parties? Is it acceptable that if it's not political parties, it's okay that these NGOs must capture the judiciary?
Commissioner, I think the position is very clear, which is that it's critical that the judiciary should be independent and beholden to no one but their oath of office and to the Constitution, and they should be captured neither by politicians nor by NGOs, but simply do their duty as independent judges.
Now, my second question, Judge, is, does experience count for anything for you? Like, do you think it's necessary for people to get an experience before they assume certain responsibilities permanently? And let me take it further that, do you still hold the same views you were holding before you acted in the Constitutional Court, or you think that your acting actually helps somehow to put you in a better and a different position?
I think experience is always helpful. I think we have had examples of very, very good judges who have had little or no experience and discharged their judicial functions with great distinction. But it is always helpful to have experience, and I'm particularly grateful that I have had 2 years on the Supreme Court of Appeal and have now had the opportunity to act in the Constitutional Court. I don't think, in other words, that you can never have an appointment without the requisite experience, but I think that it is helpful, and it has been helpful.
And will you agree with me, Judge, that acting and acquiring an experience is so helpful that it will even empower you to a point where you don't make minor mistakes mistakes, especially at that level of the Constitutional Court, because that is the highest court where you cannot afford to make minor mistakes. And part of the things that will make you not to make minor mistakes, it is acquiring an experience.
Well, Councillor, I'd say this, that I'm afraid human error is part of everyone's experience, and no matter how long one pursues a particular career or a particular line of engagement, you can always make a mistake. We're all fallible, we're all human, I am, and we can make mistakes, and we have to acknowledge that, and it's true of everybody. And if I've made a mistake, it's not because I believe I lack experience, it's because everyone can do so from time to time.
Judge, I agree with you, we are all going to make mistakes, but that is not my question. My question is, acquiring experience, especially when you go to the Constitutional Court, helps you not to make minor mistakes. Underline minor mistakes.
Yes.
There are certain things are ABCs of the Constitutional Court. And if such minor mistakes are committed at the Constitutional Court, you'll destroy the image of that court. And once you destroy the image of that court, you destroy the confidence of our people on that court. And once our people no longer have confidence into that court, it will lead into the state of anarchy. So I'm saying, do you accept that experience will help you not to commit minor mistakes? Not mistakes, minor mistakes.
I don't accept your proposition. I don't think that the kind of experience one gains, important as it is, ever prevents a minor mistake from being made. These things happen from time to time, and if they do, they're regrettable, but I also don't accept that because what you've said is a minor mistake, if it has been made, somehow that leads ordinary people to suddenly lack confidence in the Constitutional Court or the judiciary at large. People recognize, as they do in every walk of life, that people make errors, and as long as those errors are corrected and acknowledged, then there is no threat whatsoever to the institutional integrity of the courts or any other part of our constitutional structure.
You know, it is minor mistakes that ordinary people will appreciate. Those legal jargons and whatever arguments you make there, we may not be able to pick them up. But once you start engaging in minor mistakes, then that court is going to be flooded with rescission applications, and it will be forced to change its own decisions. And once it starts changing its own decisions, it suffers image crisis and confidence crisis, and that leads to our people losing confidence in that court. Will you agree with me?
Councillor Malema, I can't agree with you. Rescission is a very particular kind of procedure, and it has been resorted to more often of late. But there are very few instances in which courts make errors, but if they do, they can be corrected, and they should be corrected, and I don't believe that it leads to this wholesale lack of confidence that you suggest.
My last question is, does seniority count for anything for you? I don't know anything about law, and I'm not a lawyer, but every time I go out with lawyers, CJ, and then we go to a dinner or something, they say the senior counsel must pay because he's the most senior person there. And that they always accord respect to that senior because of that seniority. Then there will be judges. I heard JP saying earlier on, he thought he was the most senior in the room and all of that. So you've got this tradition amongst judges and by extension, lawyers, and by extension, judges who respect seniority. And it's not only in the legal fraternity or in the judicial, it's also in the church, where you can't join judge. Today you get baptized. The following day you ask the question, where are the pastors sitting? After being baptized, you give yourself some time to familiarize yourself with the processes there and allow the seniors to take you through and teach you. So my question is, does it really, seniority, does it matter to you? Because I'll ask you why, I'll tell you why I'm asking you this question, Judge. I respect you very highly, and those who are in my legal battles respect you very highly. Some of them nominated you. But I've got a problem that and you can see that we consider you very highly. We appointed you and you are being given opportunities to act and all manner of things. But you are in this hurry to a point where you even want to pass the people you found in the judiciary and go and lead them at the Constitutional Court. Why can't you give yourself time? You are now acting. Earlier on when we interviewed you and told you about acting, you had a different view. Now you are acting. Can't you give it some time to continue acting and accumulate the necessary experience? Then this argument of seniority and minor mistakes and experience will fall off and you assume that position properly without anyone having questions. Seniority, does it matter really to you?
Yes, Councillor, I don't think we value seniority just for the fact of seniority. We value seniority because it sometimes represents cumulative knowledge and experience that can be usefully brought to bear. And that's sometimes valuable, and we take account of it for the reason of its substance, not simply because it is a rank that has been attained through the passage of time. I think in my case, it's a question of how the Commission and yourself assesses the fact that I have had a very lengthy career at the bar in which I have done a great deal of constitutional work over a very long period of time. I have had experience across many areas of law, and I have acted in the judicial capacity in the WTO for some 8 years. And it's now a question of whether there has been enough further experience within the South African judiciary that would suggest that I can make a contribution. I believe that I can, and I'm happy to further explain what that contribution would be. But if it is the case that you or the Commission at large takes the view that it is only sitting judges who have sat for 10 or more years, well, then you will announce that policy and people will know where they stand. And speaking for my position, I will then become too old to ever assume a position on the Constitutional Court, and I will not be able to make that contribution. But that's a judgment ultimately for the Commission to make. It's not one that I can. I believe I have cumulative experience of some value to a contribution I can make at the Constitutional Court, and if I'm given the opportunity, I should love to do so. But if that isn't the requisite combination of experience that counts for the purposes of appointment, well, then I will accept that, and that is how things will be.
Thank you, CJ.
Thank you, Commissioner Malema. I don't have anyone on my list anymore now, but I see Commissioner Singh, and after that, Minister. Oh, I'm sorry, I'm sorry, Commissioner Singh, I'm sorry. I think I forgot that I was still with the commissioners who are attending virtually. Was that Commissioner Breitenbach?
Yes, thank you, Chief Justice, if I may.
Yes, you go ahead.
Thank you, sir. Good afternoon, Judge Unterhalter.
Good afternoon.
My question is a simple one. What, in your view, are the factors to consider in deciding whether or not you are sufficiently conflicted in any given matter to justify your recusal as a judge? Thank you.
Well, a conflict of interest arises in a number of different circumstances, but it would usually be one where there is some private involvement that one has which is at stake in the litigation, and hence there would be an apprehension that one could not bring an independent mind to bear. So standardly, it is conflicts of interest that give rise to recusals, and that's the one category that would ordinarily require a judge to step away from a case if they had interests in the litigation or its outcome that were peculiar to their private concerns, and hence they would be operating in a conflict of interest and duty. And I think that's fairly well understood as a basis upon which a judge would recuse themselves.
Thank you.
Thank you, Commissioner Breitenbach. Any other commissioner attending virtually who has a question for the candidate?
Nothing from me, Chief Justice.
Thank you, Commissioner Barnard. Commissioner Shabangu Mdawe, have you got any questions?
From me.
Nothing from you.
Nothing from me, yes.
Thank you, Commissioner Singh.
Thank you very much, Chief Justice. Good afternoon, Judge.
Good afternoon.
Firstly, I just want to confirm, Chief Justice, that if you take us out for dinner, or in our case, Parliament, the Speaker, then the Speaker has to pay, because that's seniority as far as I'm concerned. So I think they must expect a big bill from all of us when they take us out to dinner. I think one of the significant appearances that you made, Judge Unterhalter, when you were not a judge, and I'm speaking from a parochial point of view in the Constitutional Court, when you secured us, when I say us, members of Parliament, the right to introduce private members' bills.
Yes.
And that was in 2012, where that right was not a given right at that time. And late Honorable Mario Ambrosini took that matter, and SC Unterhalter represented us MPs, and I think that was a significant ruling by the Court, and it really helps us now as members of Parliament to move forward. That's as an aside, but just to say thank you again for that. During our last interview, the Commission spent a lot of time on your participation or appointment in a leadership role or otherwise in the South African Jewish Board of Deputies.
Yes.
And I know you explained at length your position, but there were a number of articles in the papers, in various publications thereafter by different people, which is not you writing, about this matter. Now, I know you did explain the matter to us. Is there anything that you would want to add for those commissioners that were not here, or may not have followed it, or members of the public who don't have the transcript that we are privileged to have before us? Thank you.
Yes, I'm not sure that I have terribly much to add. The position, as I've described it, is that the Jewish Board of Deputies is a body that has long predated the State of Israel and is there to look after the interests of the Jewish community, and in particular deal with cases of anti-Semitism, which is a species of racism that is particularly concerning to the Jewish community. I joined on the basis that I could possibly, in a time of COVID, be of some service, and that was my understanding. It was to serve that community of which I'm part. I've indicated on a number of occasions that the views that the community, that is the Jewish community, has as to the State of Israel and so on are highly varied, and that is no part, as I've ever understood the constitutional basis of the Jewish Board of Deputies, to be anything more than its service to the Jewish community. I certainly acknowledge that in the light of the fact that the Jewish Board of Deputies is a litigant, and sometimes a litigant in the appellate courts when dealing with questions of anti-Semitism, that it would not be appropriate for me to continue to serve in such a body which is also a litigant. And it was for that reason that I stepped away from the board, and it seemed right that I should do so in the light of the issues that were raised with me. And as I've indicated, where one is in error and there is correction to be made, well, then one must make the correction and not simply dig down and simply refuse to acknowledge and refuse to correct. And that's essentially what I've done.
Thank you very much, Judge Unterhalter. Thank you, Chief Justice.
Thank you, Commissioner Singh. Minister?
Thank you, CJ. Judge, my question relates to the partial judgment versus the Minister of Justice and Correctional Services. One of the issues that the judgment was attempting to cure was a dual system of consideration of parole. But I'm asking myself that you took a decision there, which was confirmed by the Court on the fact that the parole must be considered on the basis of the date of the commission of the offense instead of the date of sentence. But there's a judgment, Van Wyk judgment. I'm sure you will also have considered it when you're considering the partial. So when dealing with the Van Wyk matters, they are dealt with also differently. You can consider them before 2004. There is a kind of regime. So I sometimes feel like it did not really cue this issue of a dual system that the Concord was trying to cue, but also that I sometimes sit with the parole that I feel like this is a gruesome kind of an offense, but a person has to be considered for parole even before they reach maybe 25 years, which was the intention of the Correctional Services Act.
Yes.
Yeah. Do you have any comment on that you think could be helpful for us?
Well, the dilemma that arose in that case, and which I attempted to resolve as part of a full bench, which then went on to the Constitutional Court, was how does one understand constitutional rights in relation to parole when the legislature has changed the scheme under which parole can be considered, particularly the time period relevant to when those who have been convicted of the most serious offenses can be considered for parole. And as we know, there was a law change that occurred, and the question was, well, is the regime of parole some part of the burden of sentencing and punishment that a person has to suffer or be relieved of? And ultimately, I found, and in the judgment with my colleagues, and so did the Constitutional Court, that there is a relationship between the consequences of one's criminal acts, including any parole that might flow from a criminal sentence, and that the relevant time to determine that burden of punishment is at the time of the commission of the offense rather than at the time of sentence. Now, there are always anomalies when one engages in a change of law, and certainly there were decisions prior to Pachla which had looked at this in a very different way and had said that in effect parole is a feature of executive discretion and simply doesn't engage this burden of punishment. I took a different view, so did the Constitutional Court, but there is certainly a view, and perhaps it's one that, Minister, you may be more sympathetic to, which suggests that parole is something that happens after sentencing and is a discretionary feature of executive decision-making and shouldn't be implicated in the notion of punishment itself. That's not the route ultimately that the Constitutional Court took, and it wasn't the view that ultimately I held, but it's certainly a view that I fully understand the weight of.
Thank you, CJ.
Thank you. We have taken 1.5 hours already with this candidate, but I don't have any further hands. The Secretariat has told me that they have been in contact with the Constitutional Court and have obtained the application papers relevant to the matter that Mr. Njesi raised. It is possible that if the candidate was given those papers, maybe that might give him all the information he needs, and he might be able to assist. I'm not sure.
Yes.
Do you think that might help?
I'm obviously very happy to look
have a look. Yes.
at what papers have been procured. What I had wanted to check on my own email, but with the assistance of the Constitutional Court, I might be able to do it here.
Yes.
Is firstly to check what applications served before the Constitutional Court, and check in that application how it came from the SCA, and then to check in the scheme of the emails that were exchanged that my concurrence in the Constitutional Court is accurately reflected on the documents that have been handed to me. But I can look at whatever materials are available and see if I can ascertain the position or not.
Is your answer that looking at the application papers that have been secured may or may not help, because you might need to look at your computers and for other things?
I think what I would be wanting to do is to check in the scheme of the emails by which one indicates a concurrence.
Oh, okay. Okay.
That
no,
I did participate
I understand, yeah.
as the documentation
Yeah.
seems to indicate. I would just like an opportunity to check that.
Yeah.
And I'd have to get access to my computer or a computer to do so.
And you don't have your computer here?
I don't, but I'm certainly, I can certainly see what I can do to get remote access to it, which may be possible if there's someone who can assist me with the computer. I can certainly look and see.
Yes.
So, Chief Justice, if I can deal with the matter today, I would obviously want to do so to assist you and resolve the question one way or the other.
I'm sorry, did you say if you can deal with the matter today?
Well, if it really just depends upon getting access to a computer and being able to remotely access my emails at the Constitutional Court. And it may be that some of the documentation is available. So I'm perfectly happy, if it would be of assistance, to try and see what is available.
Yes.
If I can try and resolve the matter today, I would obviously do so.
Okay, all right. Thank you. They will give you the papers for what it's worth, but from what you say, they might not provide the answer, because you need to see the emails that were exchanged. You want to see whatever email where you would have indicated you would have signified your concurrence with the order.
Yes.
So I think, commissioners, let's now talk about the way forward with regard to the issue that was raised by Commissioner Njesi. But I think Commissioner Schlemmer wants to say something.
Yes, CJ, it seems like the Secretariat has a computer available that Justice Unterhalter may use to get access to the material.
Yes.
And if I may, then I would like to suggest that we adjourn for an hour maybe, and then come back to give him time to have a look at it.
Yes. Justice Unterhalter, how much time do you think you might need?
If I can get access to a computer which allows me to get into my Constitutional Court emails, I don't think I'll need terribly long, but I could indicate early whether that's possible or not, so as to not detain you for any longer than is necessary.
Yes. Okay, well, maybe we should adjourn for maybe let's say 30 minutes. And if, maybe after that 30 minutes, you will tell us whether you have succeeded or not.
Certainly.
Okay.
Before we adjourn, and I think we can excuse Judge Unterhalter.
Well, let's first see. We agreed that we'll adjourn for 30 minutes. Okay, all right. So let me release you temporarily, Justice Unterhalter.
Yes, I'll leave the copy of the list of counsel with whom I've worked.
The Secretariat must take it from you.
Yes.
Yeah. We are therefore going to come back. It's now 5 minutes past 6. We'll come back at 25 to 7.
Yes. But before we can
but you
adjourn,
want to say
yes.
something, yeah?
Firstly, I think...
After the candidate has left.
yes, yes.
Okay,
Shall
we
I?
are
Am I
releasing you.
excused for now?
Yeah. Are you able to report back?
Yes, indeed. Thank you very much for the opportunity. I've managed to get hold of the application that served before the Constitutional Court and the memorandum that was provided by Justice Madlanga. So let me tell you what I've been able to ascertain. The document that has been provided to me indicates that a petition served before the Supreme Court of Appeal, and I, together with Justice Mukumi, sat on that petition.
I'm sorry, Justice Unterhalter. Thank you, Minister. The commissioners attending virtually, are you there? Are you back?
We're here.
Yes, we are here.
Oh, okay, thank you. Thank you. You may proceed, Justice
Yes, thank
Unterhalter.
you. So I have seen the document which evidences the fact that together with Justice Mukumi, I sat on a petition in the Machali City matter, and we dismissed the application for special leave. There was then an application brought to the Constitutional Court by the disappointed applicant, and in accordance with the procedures that are followed in the Constitutional Court, a memorandum was produced by Justice Madlanga in which he traversed the merits of the application, and the application to the Constitutional Court was itself attached. My concurrence is correctly reflected in the order that I've been given, and which I recall joining in respect of the dismissal of the application for leave to appeal. So it is certainly the case that I was not in a position to determine the application for leave to appeal before the Constitutional Court, having refused the petition in the Supreme Court of Appeal. I can only say that it was an error. I did not recall that I had sat on the petition. Commissioners will know that many of these petitions come and one sits on them in their many numbers. I would indicate that the application to the Constitutional Court did not in the body of the application actually reference me or my name, nor Justice Mukumi. And the order itself is an attachment right at the end of the application, which I certainly didn't take note of when I considered the application before the Constitutional Court. So I didn't see that I had sat, and I should point out, though I make no, it is also the case that none of my colleagues on the Constitutional Court noted this fact, nor their clerks who assist them in the preparation of their work. So it is an error that I made. It is the case as a matter of law that one can sit upon a refusal of an application for leave to appeal if the matter nevertheless goes to a hearing on the merits, but I accept that having sat on the petition at the Supreme Court of Appeal, I was functus officio for the purposes of sitting on an application before the Constitutional Court. It makes no difference to the outcome in the Constitutional Court because there was a quorum of judges even if my vote of concurrence is removed. So nothing turns on the outcome, but I certainly acknowledge that I didn't recognize that I had sat previously and that I should consequently have recused myself. I would indicate that I am completely alive to this problem, and in numbers of cases in the Constitutional Court, I have recused myself in respect of applications for leave to appeal, one of them being the HAL case against the MEC for the Orange Free State, where I sat not on a petition but on the full court that heard that matter in the SCA, as also in the Coral Sands versus Capitec application that was directed to the Constitutional Court, and more recently in respect of the Group 5 and Competition Commission cases. So I should point out that I am entirely alive to this problem, that having sat in a number of courts, one has to be alive to the fact that you may have sat previously. This is just a petition that I did not recognize I'd already sat on, and I made the mistake, and for that I apologize.
Thank you, Justice Unterhalter. Commissioner Nochesi.
No, I understand you, Justice. I just want to bring to your attention that the reason why I asked you this question is because the matter itself emanated from the Gauteng division, that is your division, and then it comes to the SCA, it comes to you. The CC, it comes. It's like, in my language, like wherever you go, I follow you. So that was a serious concern I have.
Yes.
And with your answer that you have given, I've got it. But now, this is the last point. What does then, because if I send an application, full application with all attachment, even if it is a letter that is not clear, as somebody who's going to decide, you need to see what is in that unclear paper. That's why judges would write back a note and say, can you clarify, can you send us a legible note, because that one. So now in this one, admittedly, you didn't read the order itself. I accept because the name appears. Where does it leave us? What does it say? In general, what can you say? I understand the apology about sitting because there are many matters. But now, admittedly, a document in an application that must be decided is not read.
Well, to be fair, I don't think that that's entirely correct. I mean, the application was fully read. It dealt with the question as to whether an interim application was susceptible of appeal. That was something that clearly, when I read the application and the SCA, we considered there were no prospects for leave to appeal. The memorandum that would accompany the application, which I've read and refreshed my memory of, made exactly the same point. So the issue is a relatively crisp one as to when an appellate court will entertain an interim order, and there are only very unusual and special circumstances where such an order is entertained by an appellate court. And so the principle is very clear. And I think there was, it's true that the very last page of the application, where the actual order of the SCA is to be found, but where my name is not reflected in the body of the affidavit, is one that I didn't have regard to. But I would point out that nobody in the Constitutional Court did either, not a single justice and not a single clerk who looked at this application. So while, of course, I take responsibility for my failure to notice this, it appears to have been an error that was made by everybody, and it is regrettable, but there is, I think, little to be said about it beyond the fact that it was an unfortunate error. These things do happen occasionally, and one will endeavor not to repeat an error of this kind.
That concludes my questions.
Thank you, Commissioner.
And I think I'm also relieved about my concern. Wherever you go, I follow.
Yeah. No, thank you. I think for the I think I can share this. Arising out of this incident, I think we may have to consider in the Constitutional Court making it a requirement that in an application for leave to appeal, the applicant should prominently list all the judges who have had something to do with that matter. And then internally within the Constitutional Court, we could also say the judge who prepares the memorandum that is circulated to all the justices about that application, who tells them what the application is about and so on, should also somewhere first page maybe mention all the judges in the other courts who have had something to do with the matter, so that is prominent. Because if in the application they don't mention the name of a particular judge, and in the memorandum the judge is not mentioned, but you only see the name of the judge if you go to an annexure, it's possible that these problems could arise. But if we make it a requirement that all the judges who have had something to do from the High Court up, who have had something to do with that matter, their names must be mentioned prominently. That might help to make sure that in future we don't have a situation where somebody takes part in a matter not knowing that it's a matter in which they may have been involved.
I think that would be very helpful, if I may say, CJ.
Yes. Thank you. Commissioner Malema?
Yeah, firstly, I just want to raise a concern with how you chair, because a matter is put on the table, we're still engaging in it. And then you come in as if you are giving a conclusion or a summary of what we had debated, because I would ordinarily expect that you give us an opportunity to engage with the matter. And then from there, you may, especially if there is a candidate before us, so that we don't sound like now we are going against what you are saying. So I wanted to make a follow-up on this matter, that now I would expect, and it's not only for the judge before us, it means that on this matter, all the 11 judges did not see that you sat on this matter, because I'm not a lawyer. I would expect that when an appeal is made, the higher court will want to familiarize itself with who had the matters, what are the issues, and all of that. That's why even in the judgment there, your names are there. So all the 11 judges in the application for leave to appeal, none of them picks up that actually one of the judges who's going to hear this matter has actually had this matter. So more than the judge who appears before us, the whole Constitutional Court sat on this matter. The staff that sat on this matter could not pick up that one of the judges is actually the one who had the matter before. So I've got a very big problem, Chief Justice, with that response. But that is not my question. Now, I've apologized to us. But before you apologize to us and to the nation, you make some sort of remarks which suggest you want to justify that action. because you say your participation will not have swayed that judgment differently. And that is not our argument. Our argument is it doesn't matter whether the majority will still have ruled the way they did, but it doesn't help to improve and enhance the image of the judiciary. If a person who had this matter before still goes and sit on a higher structure to hear the appeal that he dismissed before, we're not talking swaying here. And once you're talking about it, it doesn't matter, even if I didn't participate, the decision was not going to be different. That is not the point. The point is the morality of it. It doesn't enhance the image of the judiciary, because remember, it's not about how the judgment goes. Whoever says the judge who dismissed me before went to sit and listen to the same thing and then dismissed me again in the higher court, then the whole of society says, how does this thing work where people can listen to their appeals against themselves? So it's not about which, was it going to be in their favor or not if I had not participated. That is not what we're talking about. And it's about the principle of recusing yourself. It has nothing to do whether, even if I recuse myself, they will still lose. No, it is in the best interest of justice to be seen to be done. Must not only be done. Thank you, CJ.
Thank you, Commissioner Malema. Do you want to say something, Justice Unterhalter?
Not really. I don't think it's got anything to do with morality whatsoever. It's got to do with an error which I think most fair people would acknowledge can be made, and as long as it's corrected, there is no harm done.
Thank you. I saw a hand that was up among the commissioners who are attending virtually. I don't know whether there is somebody who wanted to ask something.
My hand, CJ.
Oh, okay. Okay, thank you. Oh, Commissioner Klaber?
So, CJ, so it means now we are assured that if he meets the same matter in heaven, he would not repeat the same mistake.
I'm sorry, just repeat your question.
No, I'm saying it means that we are now assured that even if he meets the same matter up there in heaven, this mistake will not happen again.
Well, I certainly intend seeing what can be done to minimize the chances that it could happen again. Yes. Commissioner Lucas?
Thank you, CJ. I just put it on the record that I don't agree with the statement that Judge Unterhalter made to say no harm done, because we don't know what is the harm that has been done to the applicant. And I agree with Commissioner Malema, justice must be seen to be done. So I can't agree with the statement that said no harm done.
Okay, all right.
Yeah, can I come in on matter? Just a small matter.
Thank you, Chief Justice. I raised my hand many times, and it is in relation.
I'm sorry, I didn't see it.
No, don't worry, Chief Justice. It relates to that issue that Commissioner Lucas just raised, because in response to Deputy President Petze's explanation on how these matters are dealt with generally, I seem to recall Justice Unterhalter. Good evening, Justice Unterhalter.
Good evening.
Justice Unterhalter indicated that it's of no consequence, if that's the language I think he used. And now in response, he's said it again, that it causes no harm. My understanding, and I just wanted to ask Justice Unterhalter, is that if you are on a panel and one of the members of the panel is conflicted or is disqualified from hearing a matter, does it not contaminate the panel, or does it not have an issue for the applicant? So I just wanted us to be clear. I wasn't sure and wanted you, if you could clarify that for me.
Well,
thank you.
Sorry. I think it's a question that really turns in the following way, which is that these applications for leave to appeal are decided by way of an application on paper where each of the justices indicates their position. There isn't a hearing of the matter. It's not like it's not done as a formal court case where people appear and there's an interaction as to how the matter is conducted. So it doesn't see, when I say that I can't really see where the consequence is, it's because, as I understand it, the position is that each judge that considered the papers indicated their position, and there are 8 justices, apart from myself, who indicated that the application should be dismissed. So I didn't influence any of them to come to the view that they did. They came to their own view. And that's why it's rather different from a court case, which is heard where there are interactions that take place, and you might say that there might be some difficulty that arises. But this is a rather different kind of case, and that's why I'm not minimizing the error. I'm simply saying that each of the justices has given their concurrence in the result, and I'm not certain, therefore, that it makes a difference. But if there is a different view that is taken, that somehow the fact that I gave my concurrence to this outcome makes some difference to the applicant, well, the applicant will now be in a position to raise whatever issue they wish with the Constitutional Court. But I'm not even, I mean, they must do so as they wish. I'm not, as currently advised, I can't precisely see how it makes a difference, but there may be a legal argument that they have to make, and if they wish to do so, they will do so.
Thank you, Commissioner Sepe.
Okay.
Is that Commissioner Malema?
Is Dodov?
Yes.
Okay, I'll come to you. Let me first go to Commissioner Matolo Zepu.
Thank you, Chief Justice, and good evening, Judge.
Good evening.
I just seem to recall in your last interview where I think it was a follow-up from my question of how many black female that you trained.
Yes.
And your response was that it's a long list
Yes.
of them, and one of them is Advocate Baloyi.
Yes.
But we have been given a long list here.
Yes.
But to me, there are about 2 of them who are very junior, which I'm not sure whether you trained them before you went to the bench. And the list actually includes male, it's not the long list, that's the impression that you gave me. I wanted to find out, do you still remember really the people that you really empowered?
Yes, I do. As I have the numbers here, there are 24 women on this list, and there are 25 men. And the fact that certain people were very junior doesn't mean that they were not given opportunities. I mean, the key point about the list, and the reason that I've given it to you, is that what matters most for people in the profession and at the bar is that they are given opportunities to come and work in types of cases that they would otherwise simply not get. And traditionally and historically, women practitioners and black practitioners have often been precluded from important lines of work and have just not been given the opportunities that they deserve. And I have certainly sought to work with numbers of people to both give them opportunities to participate in the kinds of work that I did at the bar, and I, in turn, learned a great deal from them as to the things that they could contribute to the cases that we did together. So I don't think that this is a trivial list, and I don't think that my contribution was minimal.
Thank you, Chief Justice.
Thank you. We are at 3 or 4 minutes to 7. I'm just mentioning that because yesterday I think we were trying to say we should try and not go beyond a certain time, which I thought was 6 o'clock. But I know that we are here because of what happened. I just want everyone to know where we are with time. I'm going to go to Commissioner Totovu, and after that, Commissioner Malema, and then Commissioner Makwanesh. Commissioner Totovu.
Thank you, CJ. I just want to go straight to the question. I understand that the candidate says this was an error, it's a mistake, and it's a genuine mistake. But I want to ask him a direct question. With this judgment of the Concord, don't you think that your presence has blemished it, that it has contaminated this judgment? As straight and simple as that.
Well, my legal answer is that I don't think it has, for the reasons that I've already given. But if the applicant takes a different view, it will make its application to the Constitutional Court.
No, leave the application aside, the applicant aside. The applicant has brought the matter before the Concord. The Concord has issued a judgment where you were involved in the way that it has been explained here. Now, my question is, and let me say my respective view is, this judgment of the Concord, the highest court in the land, has been blemished by the fact that you participated in this particular proceedings. That's all that I'm saying, and I want to hear your response on that.
Yeah, my response is that I don't think it has been. I think that the application was carefully considered by all the judges, including myself, but let's deal with the other judges. Each one of the justices gave careful consideration to the matter and arrived at a unanimous conclusion as to how the matter should be dealt with. And so the fact that I should not have added my concurrence to the position taken by the other judges, I don't think in any way means that this is a problematic decision. It is a proper decision rendered after proper consideration by all the judges on the court who should have sat. And the applicant therefore got the hearing and result that the applicant deserved.
Okay, thank you, CJ. During the deliberations, I will definitely deal with this particular matter. If I may analogize, it's like Chiefs playing against Barcelona, and Barcelona has got 10 players, and you say, in any way, Chiefs was going to lose. That's not how it works in my view.
Commissioner
Thanks.
Totovu. Commissioner Malema.
No, CJ, I wanted to correct small mistake that the judge committed. He said it's another mistake which is committing right in front of us here. He says he recused himself on a matter involving Department of Education, MEC of Department of Education from Orange Free State. There's no such a province called Orange Free State. These names are changed for a reason. And if a judge just sits there and call a name of a province wrongly like that, it's an exception that it's an issue that we take serious exception from it, some of us, because we value these names. That's why we replace these colonial names. Thank you, CJ.
Thank you. Commissioner Makwanishe.
No, I'm covered.
You are covered. Okay, all right. Commissioner Pillay.
Thank you, Chief Justice. Good evening, Justice Unterhalter.
Good evening.
Justice Unterhalter, I did a rough calculation of the matters that you list in your application, and it roughly amounts to about 350 judgments listed in your application. Now, I'd like you to juxtapose that for a second with the list that you've provided us, which sets out the number of Black and Women Council that you've led. And if one had to distill from that list, the Black women specifically that you've led, it totals to no more than 7 women.
I have 8, but you may well be right.
Well, let's give you the benefit of the doubt and say it's eight women. I really want to hear you on this, Justice Unterhalter. Are you saying that you're looking at the amount of work that you've managed to get under your belt in the time that you were at the bar, your opportunity for passing on skills to black women practitioners, the power that you wield in doing so? So, given your reputation, given your demand in the market, you were in one of those very rare situations where you could dictate who you wanted on your matters. I mean, your reputation speaks for itself. And in that context, and with that kind of power that you wield, you literally put up a list of 7 or 8 black women. Most of them, and for those of us that know the names, the one thing that jumps out at you is that most of the women listed, the black women listed, were very junior at the time that you left the bar. So certainly it hints to me that at least 1 or 2 or maybe 3 of them were pupils at the time that you involved them in your work. But it is a cause for concern that there are no senior black women that you've worked with, firstly, despite, and this is the real nub of the issue I want to raise with you, despite the power that you wield.
Yes. I can take the point that you make, which is that looking at this list, the black women on the list are more junior. I'm not sure that I accept the criticism, though, that somehow is a problem. Seems to me that it's much, much more important to give opportunities to those who are starting out and are junior to participate in cases. More senior black women, important as their professional rise is, have more opportunities just by dint of their seniority and the fact that they are established. So I'm not certain at all that the criticism is a fair one, in that one would have thought that some credit would be given for the fact that bringing more junior black women into cases of some importance would actually give people opportunities that they could benefit from, and I think did benefit from. I accept that everybody could be better than they have been, but I'm not certain that you've generated lists of people that from other practitioners of very long standing who've appeared here that rival this list. And I think, frankly, that I took it upon myself at the bar to involve myself with black practitioners and women to a not inconsiderable degree. And I was privileged and happy to do so. And I think if you speak to some of the people on this list, you would learn that they did derive some benefit from their involvement in these cases.
Justice Unterhalter, I have absolutely no doubt that they did derive benefit. But can I just follow up on your answer? So what you've just said now is where you have worked with black women. It was on the basis of you extending an opportunity to those women.
I think that was certainly the result.
Can I then, the logical consequence of that is that you haven't worked with a black woman junior where you depend and you trust that junior to work with you on a matter. In other words, you rely on the skill and the contribution that the black woman junior brings.
I don't accept that proposition at all. The manner in which I worked, and had I had the pleasure to do so with you, is in an extraordinarily non-hierarchical way, in which I participate and was happy to participate very fully and enjoy the benefit of the skills that practitioners at different levels had to offer. So this wasn't a question of some grace and favor that I was conferring on very junior black practitioners. I enjoyed working with them and enjoyed the skills and benefit of the thoughts that they had to offer and the involvements that they had in the cases that we did together.
Justice Unterhalter, I represent Advocates for Transformation, so you will appreciate why this is a burning issue for us. I've already put to you what my concerns are about your list and how the names jump out at you and the inferences which those of us who are familiar with the names will draw. Is there anything else you want to add in terms of your selection of black women specifically to work with?
No, all that I have to say is that this was part of what I did in my practice, and I believe that I derived benefits from those that I worked with, and I believe they did too.
Thank you, Chief Justice.
Thank you, Commissioner Pillay. Okay. Commissioner Kane.
Thank you, Chief Justice. Just to follow up on that, Judge, you are aware of the advocacy training program that the bar runs, and I would like you just to describe your role in that regard whilst at the bar and whilst on the bench.
Yes. It was an important part of what I endeavoured to contribute to the life of the bar, both when I was at the bar and thereafter. There are training.
Please just bring the mic
I'm
closer
sorry,
to you.
I'm sorry.
Yes.
The training is a very, very important part of what the bar offers to both pupils who come to qualify as advocates as well as practitioners who have some standing within the profession. I've always thought training to be a matter of fundamental importance and a way in which practitioners who have some experience can endeavour to assist those who are coming to the bar and those who are at the bar. And so I have, over a very long period of time, worked with pupils in their training, practitioners in their training, and the annual training that takes place at Wallenberg is something of particular importance to me, and it's an intensive period of engagement with junior members of the bar to work with them to augment their skills. And I think that is a fundamental part of what the bar and practitioners can do, and judges can do, to contribute to the excellence of the profession and secure its future, particularly for those who are in respects disadvantaged. And it's often through those contacts and through the training that it provides that they are placed in a position to better their profession and better their performance in the profession. And to the extent that I could do so through work that I did so, and to the extent that training is another channel by which this can be achieved, I worked extensively in that way.
Chief Justice, may I have one more question?
Okay.
Judge, many people listening to you won't understand what Wallenberg is or means. Could you just give some description of your involvement in that particular program?
Yes. So the Wallenberg program is an intensive period of 3 or 4, sometimes 5 days, where practitioners of a certain number of years of experience come down to Stellenbosch, where trainers, some of them members of the bar, some of them drawn from all over the world, and judges work in a very, very intensive way over this period of time with practitioners to hone their skills. And there are particular methods that are done. It's a combination of lectures that are given, talks that are offered, and intensive practical training in respect of concrete problems where practitioners are required to work up problems as they would in real life court situations, and under those simulated conditions, we hone their skills and seek to make sure that they emerge as better practitioners. And one of the gratifying features of that process, which is then replicated in slightly different forms throughout the year, is just to see what enormous benefit practitioners derive from it and how their skills improve, and they are able to deploy them very effectively within the courts that they then go into as practitioners after the training. So it's been a source of both commitment on my part and also a source of considerable happiness that such progress can be made through these concrete efforts.
Thank you, Judge. Thank you, Chief Justice.
Thank you. Commissioner Schlemmer, and then it will be Commissioner Baloyi.
Thank you, Chief Justice. Justice Unterhalter, would you just mind to tell the Commission and the public also the role that you have played at the universities where you were involved in with moot courts, lecturing, etc.?
Yes. Thank you, Commissioner Schlemmer. I have throughout my time at the bar had an extensive involvement with academic institutions, your own institution, WITS, and thereafter with the University of Cape Town. And it's always been a particular pleasure to be involved in the academic world and be involved in the teaching that has afforded me, both at undergraduate level, but more regularly at master's level. And I have, in that capacity, taught courses and had the pleasure of seeing whole generations of students proceed through the university. The academic world and the academy is a very, very important institution in this country where we not only train people, but they come to form fundamental understandings about law and the significance of law and the contributions they can make. Part of that is through teaching. Part of it is through research and supervising doctoral students, which I've done. And part of it is through, as you've indicated, moot courts, which are done by way of the training that students receive and the exposure that they've done. That's been part of my life for many, many decades, and it's a particular source of pleasure that I have had over the years through that academic contribution.
Thank you. And you have not always been paid for that work, have you?
That is correct.
Thank you, CJ.
Thank you. Commissioner Baloyi.
Thank you, Chair. Good evening.
Good evening.
Justice Unterhalter. It's really just mine is just to clarify something arising from what Commissioner Pillay said to you. And specifically, she said that, looking at the list of the black females, yes. Some of us know who they are, and so we know they're junior. I just want to put it to you so that you could confirm. You've been appointed on the bench full-time 2018.
That's correct.
Okay, so you've been there for 3 years, pretty much 3 years, 4 years.
Well, bit more than 4 years. 4 years and a term.
Okay. Now, looking at this list, the average age of these black females that you've worked with is about 5 years. I don't know if you know that, but if you start at the bottom, the fourth person would have been in her 5th year, she's left. And then there's Zikalala there, who's in year 5. And there's Ain Simang Ayanda, she's year 6. And then C. Tabata, as you go up that list, she's year 5. And then Muvangua is year 8. So sticking with the year 5s, that generally what it means is that they would have been in their 2nd year of practice by the time you left the bar. Roughly.
I can't.
I know you don't know them so much in terms of how many years they've been there. I'm just putting this to you.
I fully accept that these were people who were starting out their careers as juniors. I completely accept that. Okay. I can't confirm exactly how many years call they would now have. I mean, my recollection is that some of them have rather more years, but you would know that better than I. Yes. Because a number of these people were in my group and they had been there for some time before I went to the bench. But you may have the figures yes. more accurately than I.
Sorry, I'm just making a simple point that if we work on the basis that the number of years that I'm giving are correct,
yes.
you would have worked with them at the tail end of your career at the bar. So in the last 2 years of your career at the bar, because we've established that you are now about year 4 on the bench.
Yes.
That's all I'm trying to establish with you.
I can go back, I mean, this list has been, it may not even be complete, but I've generated it from the law reports where they appear as my juniors in reported cases. Obviously, there are a great many cases beyond this, and if it was a matter of importance to you, I could, at this rather advanced stage, try and go back and look to see exactly when I was briefed with various people and at what stage. But I accept that these were junior people, and they may well have been towards the end of my period at the bar. But I could go through and look. I mean, for example, some of the cases that they were involved in were certainly considerably before the last couple of years at the bar. And because I've derived it from the reported cases, I can give you the cases, the reported cases, and you can satisfy yourself as to when those cases were decided and when they're reflected in the law report.
Yes. No, I'm not asking you to. I was just checking the numbers. If you work off the numbers, their ages as I've given them, am I correct to reflect that if someone is year 5 today, you would have worked with them towards the end of your career at the bar?
That would be true as a matter of arithmetic and logic.
Yes. Thank you, Chief. Thank you, Chief Justice.
Thank you. I think there are no further hands. So at this stage, I want to thank you, Justice Unterhalter, for once again availing yourself. I think I had already given you a chance to say something, I think, earlier on, or not?
I don't think so, but...
yeah, if there are 2 or 3 points that you would like the commissioners that you would like to emphasize to the commissioners to take into account as they consider your candidature, I'll just give you about 3 minutes to emphasize those points.
Yes, thank you for the opportunity. I think I would only make 2 or 3 points. The first of them is that over the period of my career, I have engaged with law in a variety of ways. Mine was never just the narrow path of professional endeavor at the bar. I have, as I've sought to indicate through answering numbers of questions, sought to engage law through the prism of academia, through practice at the bar, through engagements with NGOs, both as a matter of pro bono work, but also through involvements in their work directly, such as COWS. I've also seen work in a whole variety of dimensions, which was done through pro bono work that I committed myself to. And they're not just those that are reported in the law reports, although those I have listed in my CV. I was involved in endeavors to reformulate the National Water Act with then Minister Asmal. I was involved with some of the very early work in respect of what became class actions in respect of the asbestosis claims against Gencor. So I have sought in a whole variety of ways to engage law, both from the perspective of the way in which civil society uses law to pursue the many, many ways in which law can benefit people generally in the country. I've seen it institutionally through acting for various ministers, and so I understand how law is engaged by the executive and the interests that the executive has. I've been involved in institutions and their work, such as the Competition Commission and ICASA, and the regulatory roles that they've played and how those are reflected in law. And I have, of course, as I've indicated, had a lengthy period of time of involvement in constitutional law, and the Constitutional Court is a place where I would very much wish to serve and very much wish to offer some of the experience that I've had. So that's the first thing I wanted to say. The second thing I just wanted to mention, and this is around innovation within the court system, I was one of the people very much involved in the resuscitation of the commercial court in Gauteng. It's very important, at least as far as I'm concerned, that the court system institutionally develops, that it is responsive to the needs of the country in its different dimensions. One of the things that has happened in this country is that a great deal of commercial litigation has effectively become privatized through private arbitration. There are many virtues that attach to that, but it's equally important that the courts remain places where important commercial decisions, cases come, and where precedents are set, which will be valuable to a country that is seeking to attract investment and where commercial law, amongst many other areas of the law, count significantly. And I think, therefore, that I would endeavor, were I to ultimately be appointed, to keep that sense that the institutions of law are fundamental to the Constitution and the constitutional values that we all savor and consider so fundamental. And I would want to make my contribution to the Constitutional Court, which stands at the apex of a system that ensures that our constitutional values have life and dynamism, and that it is part of a court system that is responsive to the needs of a changing society where there's much to be done, many challenges to meet, and in which the law and its institutions can play a fundamental role.
You have 1 minute left.
I've said my piece. Thank you, Chief Justice.
Yes, thank you very much. Once again, thank you for availing yourself, but you are now excused.
Thank you so much.
Thank you.